Has filed a counter-affidavit in the Supreme Court opposing a plea to ban politicians permanently from contesting elections upon their conviction in criminal cases. Now, the government says that the period of disqualification is a matter which is purely within the domain of the legislative policy and not the judiciary. It's basically now being seen as a situation where the politicians get to decide their own fate. How so? Let's break down the details for you. What really is being followed in the Indian law at the moment as we speak. Section 8 of the Representation of People's Act 1951 bars convicted politicians from running in elections for 6 years after completing their sentence. This applies to certain listed crimes and any conviction with a jail term of 2 or more years. Meanwhile, Section 9 of the Act prevents those removed from government jobs due to corruption or disloyalty to the country from contesting elections for 5 years after their dismissal. And the interim application, that is currently the hot topic, which has been filed by the lawyer activist Ashwini Kumar Upadhyay in 2017, calls for a lifetime ban on convicted lawmakers by challenging the validity of Section 8 and 9 of the Representation of the People's Act 1951 in certain respects. But is the petition all so wrong? We accessed analysis data by ADR of 4,033 MLAs, and according to the same, 1,136 or nearly 28% of the MLAs in this country face serious criminal charges. Moreover, 31% of the MPs also face criminal charges. Now, these people get to decide their own fate. How valid is that? While centers oppose the plea seeking ban on convicted politicians, is it valid for politicians to be given this kind of a concession over and above the common man who, remember viewers, doesn't even get a government job if convicted in this lifetime?
We welcome the Honorable Supreme Court's decision not to impose life ban on politicians who are convicted.
तभी नरेंद्र मोदी जी की सरकार इस बात को तय करे और वह ये डिसाइड करे कि क्या टाइम बाउंड होगा, उसको सुनिश्चित होना चाहिए सरकार की ओर से। सुप्रीम कोर्ट ने अपना ऑब्जर्वेशन दे दिया है इस पर।
Let's quickly open this up with our guests who are joining us this evening. Deshratan Nigam, lawyer and political analyst, continues to stay on with us, along with Ashutosh Srivastav, a lawyer who joins us on the broadcast. Good evening to you both, gentlemen. Deshratan Nigam ji, thank you for your patience. So let me begin with you before I go across to Ashutosh. What do you make of the central government stance so far? Interestingly, the petition was filed by Ashwini Kumar Upadhyay, now with the Bharatiya Janata Party. So very interesting dynamics there. But how do you see this playing out? The Supreme Court is going to take this up again. The central government once again reiterating that this lies in the domain of the legislature, not the judiciary.
Yes, absolutely. I think the stand of the centre is very clear. These are policy matters to be decided in the parliament and by the people of this country. And any party, if he wants, if the particular party or an individual wants any enhancement for a ban for more than 6 years or the life ban, can move a bill in the parliament and the same can be discussed threadbare. And certainly it is not within the domain of Supreme Court. Supreme Court is not competent to deal with the social issues and then converting them into policies. This is purely a social issue coming out of the society, and how much punishment should be there for the netas. Yes, the datas can be gone into when once some kind of a bill comes. It can be sent to a standing committee of the parliament. They can discuss based on the data whether there are repeat offenders or not. If there are repeat offenders, then it can be increased. The time frame can be increased. So various issues can be there and they can be discussed threadbare. Yes, if the 6-year ban, the data shows that the 6-year ban is not being very effective, then there could be a possibility of enhancing it to more than 6 years or to the life ban as being suggested by Ashwini Upadhyay's PIL. But the fact remains, certainly it cannot be decided in the Supreme Court. I think Supreme Court should abstain from entering into such kind of policy decisions, because it may have a different consequences. Suppose Parliament tomorrow brings a bill and it is passed, converting into a life ban for a convicted neta for contesting elections, then it will have a social acceptability of all the people, in the sense it has been passed by the people's representative, and there will be acceptability. Otherwise, something like, you remember Shah Bano's case, the Parliament overturned it. Parliament has the power. If suppose Supreme Court tomorrow says it will be life ban for such kind of convicted netas, Parliament will be well within its domain to overturn that judgment, because it appears center has taken a stand. What other parties are saying will be a matter of debate in the Parliament, but I certainly feel Supreme Court should not encroach upon the legislative domain of the Parliament.
Okay. Ashutosh, before I go across to Shailesh Gandhi, former Central Information Commissioner, who's also through with us. Ashutosh, should the Supreme Court intervene or can the Supreme Court intervene? That's the distinction I want you to lay emphasis on. Can the Supreme Court intervene? And if it can, to what capacity, to what extent? Because a lot of commoners are saying that why should there be an exception for netas in the country, if not for us?
Supreme Court can only interfere when it, thinks that certain laws have become ultra vires, or if it is against the public policy, or maybe it is something which is unconstitutional. And it is against the basic principles of natural justice and the law in the country. Now, here in this case, if you talk about Section 8 of the Representation of People's Act, which we know that it prohibits any politician to contest elections for 6 years if they are convicted, for 2 years, or for certain offences which are mentioned in the schedule. So now, this is the law which was made by the Parliament itself. Now, if somebody says, no, this punishment is less and they should be barred for the lifetime, it is something I'm sure the Supreme Court will not intervene, because it becomes the policy making procedure.
But what does past precedent suggest? Hasn't the Supreme Court also to an extent opined that if at all, there are decisions that need to be taken that the Parliament is merely sitting on, then the Supreme Court or judiciary very much can intervene in its own capacity?
No.
No, see, if that's what I said. It is not a new law which has just now been formed and the Supreme Court comes and says, no, this is against the principles of the of the Constitution. This is against the basic principles of the Constitution. It is not the case. This is the law which has already been made since years together, and there have been judgments also considering the same issue. Recently, we saw that it happened in the case of Sri Rahul Gandhi also. And then he went to the High Court and to the Supreme Court, and then his conviction was stayed. See, what happens, suppose if somebody is convicted today, and if he goes and challenges that conviction of the trial court to the higher court, and if it is a stayed and the matter is going on for, let's say, another 6 years or 10 years. So after 6 years, he won't be able to contest the election otherwise.
No, cases of disqualification is one. I'm also talking about criminal cases. And the seriousness of the two is extremely different.
First of all,
the magnitude is beyond comparison.
Yes, I'm coming to that. Now, suppose if it takes 10 years or 15 years to decide the, the revision, that is the appeal which has been challenged before the higher court. So he won't be able to contest the election. And what happens when after 10-15 years, when the higher court comes to a conclusion that his conviction was wrong and he was wrongly convicted by the trial court, then it is completely injustice to that particular, a person who is to contest the election. So that is what has to be kept in mind. Now, there have been many decisions in different laws as well, where the Supreme Court has given the opinion that the Supreme Court will not intervene because it is a policy making process. And since being the representatives of the people, let the Parliament decide. Let these legislators decide, because they are representing the people, so they can take care of the view of the people.
You can't draw a clear line ever, right? Mr. Gandhi, what are your views on this? When do you draw a clear line on, whoever is convicted, whatever punishment has been given to them by the courts, they can weigh in on their legal options? It's an unending story. But should people with criminal antecedents be allowed to contest elections in our country? That's one question with several layers.
I think in India, we turned international jurisprudence on its head. the normal belief is innocent until proved guilty. For the sake of elected representatives, we say guilty until proved innocent. This approach needs to change. I personally feel this is an issue for Parliament to decide, not the Supreme Court.
Okay.
Supreme Court should actually basically look at the laws and decide based on the existing laws. If they do that effectively and in reasonable time, these problems will not occur. I think the number of people who have stood for elections the second time after getting convicted must be very few. So it's a non-issue which is being played up for reasons that I can't understand.
Okay, Mr. Deshrata Nigam wants to come in also. Where I do seek a greater explanation is, Mr. Nigam, while everyone here seems to be suggesting that the Parliament must take these kind of calls, if there are a certain number of MPs in Lok Sabha, Rajya Sabha who do hold a criminal record, I'm not talking about conviction, I'm just talking about they are facing serious criminal charges. Do you think that Parliament is going to be able to arrive at a conclusion which goes against the current 6-year ban? Because what we've seen essentially is none of the political parties come out and challenge the decision or the stance that has been drawn by the central government here.
Well, Christine, it's a very interesting question because it raises a question of conflict of interest.
Yeah.
Because once the tainted people, I would not call them tainted, certain allegations are there, they would not be very keen to, have such kind of a law. Then you can decide as it is decided, like if it's a bench, court's bench, which has a conflict of interest, they're recused from hearing that particular matter. Similarly, such people should be prevented from voting. Their voting rights in the Parliament should be taken away. As a suggestion, I'm saying. And secondly, even if you wish to maintain a 6-year ban, let us have another layer of punishment in the sense that these people should not be allowed to take in any political activity. Contesting ban is all right. For 6 years, they should not be allowed to take any part in any political activity. Otherwise, what happens? They continue to take part in the political activities, but start making bases, and after 6 years, they come back as if nothing has happened. So another layer of punishment can be added in the sense no political activity, a ban on political activity for 6 years, also co-terminus with the 6 years ban.
Okay, no, because we're seeing, so many other things play out on the sidelines. Amritpal Singh, for instance, has been in jail behind the bars and has been contesting elections. So there are multiple stories that are being spoken of by the Aam Janta who say, हमें तो सरकारी नौकरी भी नहीं मिलती. If we are convicted in any particular case, we don't even have that option. So why this kind of an exception for these politicians, Ashutosh?
See, first of all, there is difference between conviction and the criminal antecedent, considering the accused to be under trial prisoner. So suppose if somebody is under trial prisoner, as of now the trial is not concluded and the accused has not been convicted. That means the offense has not yet been proven. So at this stage of a period of time, at this stage, it cannot be said that the particular accused has really committed an offense. It is only that the allegations have been leveled against a particular person, but it has to be proven in the court of law by the due process of law under a trial. Now, suppose if somebody has been booked for certain offense and he is yet behind the bar and the investigation is going on against him, the trial is yet to be conducted and concluded. So in those circumstances, Section 8 of the Representation of People's Act does not apply. And in that case, this person who is not yet convicted can contest the election. The basic principle here is that a person has to be treated innocent unless and until proved guilty by following the due process of law. So this is what the principle of law applies here in this case. Now we are talking basically about the convicted accused whose guilt has been proven in the court. So in that case, the ban is for 6 years. But even in those cases, we have seen that it depends on the judicious mind of a trial court, how it takes it. And if it goes for challenging those orders in the higher court, many a times it is changed, because merely on certain evidences or maybe the investigation report and the witnesses, their statements, documentation on record, the court reaches to a conclusion. But whether those conclusions are correct or not, that also needs to be, again checked by the higher court when this accused goes and challenges those conviction orders.
Okay.
So that
So
also
a lot of
goes
ifs
on.
and buts, and it's not as simple as it sounds. So the central government is also weighing in on the several legalities of the same. But like I said, it's interesting that I see this coming, this contention coming from a now BJP leader who continues to weigh in on this with as many legal arguments. But Mr. Gandhi, what about those who say leave it to the janta ki wisdom? Does that argument hold? You know, so many of them have come out to say that, you know, if the people want to vote those with a criminal record or a past or a history and want them back in the parliament, then nobody should have a problem with it.
Today in India, the problem is that what we call criminals are people who are charged with crimes. 78% of our people in prisons are under trials. We have a failed judicial system. Unless we correct that, we'll keep on going round like this.
But then political parties should not take pot shots against their political rivals while citing all of those cases that are still being investigated.
The problem is our judicial system takes so long, and we've accepted that it will take so long. In Europe, the average case length is 6 months. In India, the average case length is 2.5 years. Unless we get a proper judicial system in place, this will keep happening. Because we call people who are charged with a crime as criminals. This is almost like saying, if you want to apply for a job, how many abuses were hurled at you in the earlier year? And that will be a criteria for deciding whether you are good or bad. What we call criminals is not criminals, but criminally charged with crimes. And people have seen through this and have discounted this completely, very wisely, I believe.
Okay. Mr. Deshratan Nigam, the point that I was trying to highlight, you know, when in election season, for instance, be it BJP against the Aam Aadmi Party or other political opponents in other states, we've seen them more often than not talk about the right taint or the criminal taint that some of these politicians carry. But how is all forgotten in the Supreme Court when it comes to cases such as this?
Well, in fact, one of the biggest paradox of such a system is that huge amount of politically motivated cases are also, filed against the political leaders. And how to distinguish between the genuine ones and the politically motivated one is a very tough thing, and a person has to go through trial. And the courts are the ultimate, authority to declare a person innocent or not. So therefore, these, our Criminal Procedure Code also has a system where somebody who lodges a false case should be hugely punished, which provisions are not very, used by our courts, whether it is a civil case or a criminal case.
I'm simply trying to understand the political scheme of things. If you know where I'm coming from, Delhi elections is a case in point. We do know the kind of candidates that were fielded by, let's say, AIMIM. Delhi riots being a case in point. And the Bharatiya Janata Party that today stands victorious in the national capital did have huge objections to the candidature.
See, there are two aspects to it. One is, giving tickets to the criminally tainted people or against whom where there are very serious allegations. The second aspect is the quantum of punishment. The two cannot be related. So therefore, if somebody politically opposes a person who has got serious allegations or his conviction has been stayed or something and is willing to contest, those are the ones I think political parties should avoid giving tickets to them. However, so far as quantum of punishment is concerned, that can be debated in the parliament. I'm not saying whether it should be increased or not increased, or life ban should be there or not there. I think it should be left to the wisdom of the parliament. And therefore, the two questions that the question that you raised, I'll split in two questions.
Okay.
One is in the negative and second one is in the affirmative.
Okay, interestingly, all political parties seem to be on the same page when it comes to the central government's arguments, in this very case. I don't know how that paints our political system in the country, but thank you, gentlemen, so much for